Quick question, out of all 27 amendments to the Constitution, which one has never in the entire history of the country been the sole basis of a Supreme Court decision?
I don't know.
I'll give you a hint. It's not the first. It's not the fifth. It's not even the obscure ones you've never heard of. It's the Third Amendment. And I teased this at the end of the last episode because I knew what your reaction would be. The one about the soldiers living in your house? Why would that matter today?
Are you mocking me? Are you mocking me? Stop.
Here's the thing. It matters more than you think, just not in the way you'd expect. Because the Third Amendment isn't really about soldiers in your guest bedroom. It's about something much bigger. The boundary between military power and civilian life. Between the government and your home. Between the state and your most private space. And in an era of militarized police, mass surveillance, and expanding government authority, those questions are anything but obsolete. I'm JP, a former Special Forces officer with 14 years of service, having deployed to 11 countries in 3 different continents. I've operated in places where the line between military force and civilian life is either razor thin or just doesn't exist at all. I've seen what it looks like when that boundary breaks down. The founders saw that too, just in a different uniform. That's why this amendment exists. Let's get into it. All right, the text, another short one. Here it is in full. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. That's it. 32 words. Little longer than the Second Amendment, but not by much. Unlike most of the Bill of Rights, this one is almost self-explanatory on its face. No soldier gets to move into your home in peacetime without your permission. In wartime, it can happen, but only under rules set by law, not by military commanders acting unilaterally. 2 key words in there are worth pausing on. First, soldier. That word is going to become legally significant in a moment. Second, owner. Who counts as the owner? Just the person whose name is on the deed? What about renters, tenants, people who live there but don't own it? The amendment doesn't define either term. And that vagueness, in a document this short, has created almost all of the legal drama this amendment has ever generated. Now here's something that'll surprise you. Unlike most of the Bill of Rights, the Third Amendment has never been definitively ruled to apply to state and local governments. The Supreme Court has never taken that question up. We'll come back to why that matters. But first, why does this amendment exist at all? Because the answer to that question is a story most Americans have never fully heard. Let's go back in time. Okay, you're in Boston, 1768. There's a knock at your door. You open it. A British soldier is standing there, musket, red coat, full kit. He doesn't have a warrant. He hasn't accused you of anything. He hands you a piece of paper. It's a quartering notice. He's moving in. You will feed him, you will house him, and you will supply him. And if you refuse, you will be the one breaking the law.
You mother...
That actually happened to real people over and over again. And I want you to hold that image in your mind, because in about 2 minutes, I'm going to show you a case from 2011 where almost the exact same thing happened in suburban Nevada. Different uniforms, but same principle. But first, how did we get here? Parliament passed 2 quartering acts, one in 1765 and one in 1774. They required colonists to provide British troops with housing, food, and supplies. Sometimes soldiers were billeted directly in private homes, sometimes in inns and public buildings. Either way, the colonists paid, financially and psychologically. This wasn't just an inconvenience, it was a statement of power. A soldier in your home is a daily physical reminder of who is in control and who isn't. You can't escape it. You can't ignore it. It follows you to the dinner table every night.
Who are you? What's your name? Are you running a restaurant?
The founders were so furious about this, they listed the quartering of troops as a specific grievance in the Declaration of Independence. This wasn't a footnote. It was one of the reasons they went to war. Here's the layer most people miss. The founders weren't just angry about soldiers in their homes. They were philosophically opposed to standing armies altogether. They studied what happened in England in the 1650s when Cromwell's army essentially took over the government. They believed, and wrote extensively about this, that a professional military force quartered among civilians was one of the most shortest roads to tyranny. As mentioned in the last episode, the English Bill of Rights of 1689 had already tried to address this, declaring it illegal to maintain a standing army in peacetime without Parliament's consent. American founders went further. They built a constitutional wall between military power and your front door. And then, for about 180 years, they never really needed to use it. The US built bases, soldiers lived in barracks. The amendment faded quietly into the background until Henderson, Nevada, and that story is coming up next. Because this is the least litigated amendment in the Bill of Rights, we don't have that kind of long Supreme Court history we talked about in the Second Amendment episode. What we have are 3 significant cases, and we're starting with the one I just promised you. Mitchell versus Henderson, Nevada, 2015. Okay, you're in Henderson, Nevada, July 10th, 2011. Anthony Mitchell and his parents live on the same quiet street. That morning, Henderson police show up responding to a domestic violence call at a neighbor's house. The neighbor has barricaded himself inside, Police want a tactical advantage, and they've decided Anthony Mitchell's house is the perfect staging position. They call him and ask if they can use his house. He says no. What happened next, according to the lawsuit, is extraordinary. Police break down his door, they shoot him with pepper balls as he lies on the floor, and they handcuff him, arrest him for obstructing an officer, and occupy his home for hours. Then, they walk across the street and do the exact same thing to his parents.
Oh, hell no.
All criminal charges against the Mitchells were later dismissed. They sued, and one of their claims, the one that made national headlines, was the Third Amendment violation. Police, they argued, were functioning exactly like soldiers when they forcibly occupied civilian home without consent. The federal court threw it out, however. The judge ruled that municipal police officers are not soldiers under the Third Amendment. The right tool for this situation, he said, was the Fourth Amendment, which prohibits unreasonable searches and seizures. We'll get into the next episode. Not the third. Now, to understand why the court ruled that way, you need two pieces of legal context that came before Henderson. Think of them as the foundation the ruling was built on. Griswold versus Connecticut, 1965. The first major Supreme Court mention of the Third Amendment didn't actually involve soldiers at all. In 1965, the court was deciding whether married couples had a constitutional right to use contraception. Connecticut law said they didn't. In striking that law down, Justice William O. Douglas needed to explain where the right to privacy comes from, because the word privacy doesn't appear anywhere in the Constitution. His answer: it lives in the penumbras, the shadows, cast by multiple amendments working together. The First, Third, Fourth, Fifth, and Ninth Amendments all imply in their different ways that the government cannot intrude into your most intimate spaces of your life. The Third Amendment, in other words, was being used to stand for a principle broader than soldiers: the sanctity of the home as a protected private space. It's been used this way ever since. Less as an act of right, more as evidence that the Constitution cares deeply about keeping the government out of your most personal spaces.
No, this is my private area, my place of zen and peace.
Ingblom versus Carey, 1982. The most significant direct interpretation of the Third Amendment came not from the Supreme Court, but from a federal appeals court in New York. In 1979, New York State correction officers went on strike. The state called in the National Guard to run the prisons while the strike was on, and then housed those National Guard troops in the dormitories where the striking corrections officers had been living. The officers sued, claiming their Third Amendment rights had been violated. The Second Circuit Court of Appeals ruled in their favor on two critical points. First, National Guard members count as soldiers under the Third Amendment. The protection isn't limited to active duty federal military. Second, owners includes more than just property title holders. It includes the tenants and residents who have a legitimate expectation of privacy in a space, even if they don't technically own it. It also held that the Third Amendment applies to state governments through the 14th Amendment. Though critically, the Supreme Court has never confirmed this, Ingblom is a binding precedent in the Second Circuit only. So here where things stand. The Supreme Court has never decided a case purely on the Third Amendment grounds. The amendment has never been definitively incorporated against the states. The definition of soldier remains unsettled beyond the National Guard. And as police forces increasingly use military equipment, military tactics, and military training, the question of where law enforcement ends and military occupation begins is becoming less theoretical by the day. Some legal scholars have begun asking whether the Third Amendment has anything to say about digital surveillance, whether government agencies quartering themselves in your devices and data might one day constitute a modern form of exactly what the founders feared. No court has gone there yet, but the argument exists. And given the Bruin decision's emphasis on the historical analogies, which was covered in the Second Amendment episode, it may not be as far-fetched as it sounds. So why should you care about an amendment that's never been used to decide a Supreme Court case? I'll tell you why. Because the Third Amendment is doing something the other amendments in the Bill of Rights don't do as explicitly. It defines the relationship between the military and the civilian population of the United States. It's the only place in the Constitution that directly addresses that boundary, and that boundary matters. Consider this: the Posse Combatantes Act of 1878 prohibits the federal military from being used for domestic law enforcement. That law exists because of the same fears the Third Amendment was written to address. The fear of the military apparatus turned inward against its own people. Consider also, the United States has seen significant growth in the militarization of domestic police forces over the last 3 decades. Programs that transfer surplus military equipment to local law enforcement, SWAT teams deployed for nonviolent situations, police departments acquiring armored vehicles, military-grade weaponry, and combat training. The Third Amendment doesn't directly regulate any of that, but it represents a principle that is deeply relevant to all of it. That in America, military power and civilian life are supposed to be kept separate. That your home is a protected space. That the government, in any form, cannot simply occupy your private life because it's convenient. And there's one more thing we're sitting with. The Third Amendment is the only amendment in the Bill of Rights that is essentially dormant right now. It has no active body of case law shaping it. That means the next case, whenever it comes, could define it for a generation. Whoever brings that case, and whatever the court decides, will be writing a chapter of constitutional history that hasn't been written yet. So here's the summary. The Third Amendment was written because British soldiers literally occupied colonial homes, and the founders built a constitutional wall between military power and private life to make sure that never happened again in America. In practice, that wall has rarely been tested. We have one meeting appellate court decision, Engblom, that expanded who counts as a soldier and who counts as an owner. We have one high-profile attempt, Mitchell, that was turned away because courts still distinguish police from military. And we have a handful of Supreme Court opinions that cite the Third Amendment not as a primary right, but as evidence of a broader constitutional commitment to privacy and the sanctity of the home. The Supreme Court has never taken up the amendment directly. It remains the least litigated, least defined, and in some ways, most open-ended provision in the Bill of Rights. Which means it's also, in a strange way, one of the most interesting, because its core principle that the government cannot use force to occupy your private space touches something fundamental about what it means to live in a free society. The Third Amendment isn't obsolete, it's waiting. All right, I'm gonna leave you with an interesting quote by William Pitt the Elder, who was actually a part of British Parliament in 1763. Quote, "The poorest man in his cottage bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England cannot enter. All his force dares not cross the threshold of the ruined tenement." End quote. All right, if this episode was useful, please subscribe, because in next episode, we're into the Fourth Amendment, search and seizure, warrants, your phone, your data, and some Supreme Court decisions that are reshaping privacy law right now. I'll see you then.